A criminal trial is the one arena in our society where the government can legally strip away a person's liberty, or even their life. It is the ultimate imbalance of power. To check that massive authority, the system operates on a strict rule, the presumption of innocence. If the state accuses you of a crime, you do not have to prove you didn't do it. The burden rests entirely on the government to prove you did. They have to clear the highest standard in our legal system, proof beyond a reasonable doubt. The prosecution must establish every single element of the crime so thoroughly that no logical hesitation remains for the jury. The rules for this contest were written centuries ago. The Fifth and Sixth Amendments act as a blueprint for a fair fight. But those authors wrote for a sparse, agrarian society. They never anticipated a modern system processing millions of criminal cases yearly. To keep the courts from completely collapsing under that volume, the modern justice system has developed a series of shortcuts, and those efficiency measures often collide directly with the constitutional guarantees written on that parchment. The Sixth Amendment guarantees a trial by an impartial jury, drawn from the community where the crime occurred. Lawyers from both sides question potential jurors to weed out bias, and the Supreme Court expressly forbids excluding anyone based on race, gender, or national origin. Yet today, juries are rarely actually used. If every accused person demanded a full trial, the courts would instantly paralyze. The math simply doesn't allow for it. So the system relies heavily on plea bargains. The prosecution offers a lesser charge or a lighter sentence, and in exchange, the defendant pleads guilty and skips the trial altogether. The highest court in the land has signed off on this bypass. In 1971, the Supreme Court ruled in Santabello v. New York that plea bargaining is a highly desirable, necessary, and constitutional method of managing criminal justice. Critics point out a glaring flaw in this efficiency. To avoid the risk of severe punishment, like decades in prison if they lose at trial, many defendants feel immense pressure to negotiate. The threat of a trial becomes leverage. The guaranteed right to a jury has effectively morphed into a bargaining chip used to settle cases out of court. The Sixth Amendment also guarantees the assistance of a lawyer, but for a long time, that protection only applied if you had money to hire one, or if you were facing life in prison or the death penalty. That dynamic shifted heavily in 1963 because of a man named Clarence Earl Gideon. Following his Supreme Court case, Gideon v. Wainwright, the government is now required to provide an attorney to any felony defendant facing jail time who cannot afford one. These individuals are called indigent defendants. To equalize the fight against a prosecutor's office equipped with trained investigators and deep resources, the state assigns public defenders or contracted private lawyers to the case free of charge. However, state and county budgets rarely match the demand. Public defender offices frequently handle massive, overloaded dockets. They lack the funding and the hours necessary to thoroughly investigate every single claim. So, while the Constitution guarantees you legal counsel, the reality of court funding means your bank account still plays a massive role in whether you walk away with an acquittal. When an adult goes on trial, the rules mandate open doors. The Sixth Amendment guarantees a speedy and fully public trial and the absolute right to stand face-to-face in a courtroom and cross-examine the witnesses testifying against you. But when a minor breaks the law, they enter the juvenile justice system. Here, those universal protections are heavily modified. This system recognizes that a teenager's brain is still developing, making them far less legally culpable than adult offenders. Plus, minors can be arrested for status offenses, acts like truancy or running away from home that aren't even illegal for adults. Because the system aims to prioritize rehabilitation rather than punishment, the Supreme Court has ruled that minors do not have the right to a public hearing or a jury trial. The doors are closed to the public to shield the child's identity. The state trades the adult requirement of total courtroom transparency for a closed environment, focusing on the privacy and future recovery of a young offender. The Fifth and Sixth Amendments function as critical shields protecting individuals from the vast power of the state. Yet, as we see every day, those protections are constantly bent by the sheer friction of reality. Our criminal courts perform an endless balancing act. They weigh a person's absolute right to fairness against the objective search for the truth and the intense financial cost of processing thousands of cases. A right on paper requires machinery to enforce it. Ensuring that poor defendants have capable lawyers or that juries remain impartial requires massive, ongoing public funding and intense judicial oversight. True justice is not a passive guarantee. It requires constant, active vigilance to ensure that the assembly line of modern law doesn't steamroll the constitutional blueprint it was built upon.